Is it live? There we go. All right, good afternoon, everybody. This is Kristen Martinez signing on for today's episode of the Martinez Law Legal Lounge. These are weekly episodes that I host every single Monday at 12 o'clock to provide an informal, no pressure type setting for you to ask all of your real estate related questions. This is open to anybody and everybody, probably most relevant to real estate professionals in any capacity. But I am here to answer your questions live. So as you join in, please make sure to say hello to us in the comments so that we know you are here. I would love to acknowledge all of you. A little bit about me. I've been a real estate attorney for a little over 10 years. I started Martinez Law back in 2015, and one of my goals was to create a way and a platform for myself to be able to educate the community and specifically real estate professionals on real estate topics. The goal essentially is to keep people out of the courtroom, try to prevent disputes and things that would lead to lawsuits and legal battles and things like that. And so these weekly Legal Lounge episodes are just one way that we do that here at Martinez Law. And so please utilize these sessions, take advantage. You can write in your questions all week long on any of our social media platforms, at my email, which is listed down in the banner below, and I would be happy to address them. Of course, you're also welcome to go ahead and type your questions in the comments, and I will answer them here live every single Monday. A couple of announcements before we get started. We have recently hired a new marketing director. I don't know if you have noticed, but our social media game has been on point lately, and it is all thanks to our new marketing director. Her name is Alexis. She started a couple of years ago actually as an intern and was just promoted to our marketing director. So her email address is just marketing@martinezlawfla.com. So make sure to send her a message and congratulate her. But all of the new marketing ideas and promotions that we've been doing, as well as our social media activity, is all thanks to her. So we're very excited about that. I also want to remind everybody that we do have a YouTube channel. So all of our video content is reposted there. Make sure to check that out. We are creating a pretty nice sized library of videos covering all different topics within the real estate area. So if you miss these weekly Legal Lounge episodes, they're all reposted there, so make sure to check that out. Finally, our monthly program, Get Real with Attorney Martinez, is scheduled. The next one is scheduled for July 7th at 10:30 a.m. We are offering both in-person and Zoom options. You can find the registration link on eventbrite.com, or you can send us a direct message or email asking us for the link, and we'll go ahead and shoot that over to you. You don't want to miss the topic. The topic this week centers around neighbors who may be driving you crazy. We're going to talk all about nuisance laws, easements, and trespassing issues. So we are looking forward to that, which again is going to be July 7th at 10:30. Again, thank you all who have joined so far. Please make sure to go ahead and leave us a comment so that we know you're here. I see my husband has joined. Brian, thank you for your comment, but also go ahead and leave your questions in the comments. That's what we're here for. I'm ready to answer those live for you. I'll go ahead and officially open us up for Q&A. I know some folks are still in the process of joining and will continue to join throughout today's episode, so I have prepared some kind of frequently asked questions that we get just in the office on a very regular basis. I could probably make a frequently asked question sheet of all the questions that we get at least on a weekly basis here at the firm. And so if I don't see any questions in the comments to go ahead and answer for you today, I'll go through some of those and hopefully you can learn a thing or two and get some benefit from those. The first one actually touches on a social media post that we did, I think, last week, and it has to do with the unauthorized practice of law by real estate agents. And so the law kind of sees real estate agents as a little bit of an in-between position. So we have non-lawyers or lay people, and then we have lawyers. Real estate agents are somewhere in the middle as far as the authority that they have to draft contracts and do certain things in connection with a real estate transaction. So specifically what the law says is that a real estate agent has the authority for somebody else to fill in a standard and pre-approved purchase contract or lease. So they cannot draft their own customized contracts or leases for a client, but they can take, for example, the FAR bar contract and fill in those standard contracts based on the information that their clients are giving them. So in practice, what this means is that, and it really comes into play when we're talking about changes to the contract or addenda. So for example, if you have a standard form addendum that applies to your transaction, you can go ahead and fill in the blanks of that standard form. What you cannot do is take a blank addendum and type in your own terms. For example, let's say the buyer and seller have agreed that the seller is going to make certain repairs or certain changes to the property prior to closing. You cannot type in your own addendum to that effect. You would have to have either a standard form addendum, or you would have to have an addendum that has either been drafted or approved by a licensed attorney. To draft your own addendum and not have it reviewed by a licensed attorney is the unauthorized practice of law, and you can get in trouble for that. That being said, it happens every single day. Most realtors probably do this, and so this is not meant to scare you, but to make you aware of what the law is in this area, and that you need to be extremely careful with drafting your own addendum, or even, at the end of the FAR bar contract where it says additional terms and it has several lines for you to type in, that would also be unauthorized as far as real estate agents typing in their own verbiage there. So one way that I have been able to work with realtors and brokerages as a whole to get around this is by drafting standard contract language or standard addendum that come up all the time. So for example, the seller making repairs prior to closing, that comes up all the time. So I can create, or the broker can create, a standard addendum, have me review it. Once I've signed off on it, now their agents are free to fill in that addendum and use them in their transactions. So I've done that for a lot of brokerages. That's one easy way to get around kind of the impracticality of having an attorney review every single addendum, especially with the fast pace of these transactions in this market that we're in today. So same goes with leases as well. You can use the standard form leases. You can fill in the information. What you cannot do is draft your own lease for a client. You cannot pull a lease off of Google and provide it to a client and have them sign it. That would be something that would have to be either prepared by or looked over by an attorney. So as you have questions about that topic, I actually have a whole presentation and training that I do on the unauthorized practice of law by realtors. So it is a much larger topic than we're going to really get into today. That was kind of a broad overview, but if you have specific questions about that topic, please send me an email, leave it in the comments. I'd be happy to address those questions. For those of you that are newly joining us, make sure to go ahead and say hello in the comments. Make sure to post your questions there. I'm here to answer your questions live. Not seeing any questions. I'm going to go through a couple of more frequently asked questions, so to speak, that I see in my law firm day in and day out. Clients calling in, real estate agents calling in, asking these questions. So hopefully you can get some benefit from those. The next topic that I'll go ahead and address in that category has to do with ladybird deeds. I get asked about these a lot. I also get calls asking, how can I protect my assets, or how can I avoid probate if something were to happen to me? They're asking for a ladybird deed. They just don't know it. Kelly, thank you so much for checking in and for attending. Feel free to go ahead and post any questions that you have in the comments, and I would be happy to address those. So back to ladybird deeds. This is a type of deed that can be a very useful tool to protect assets and also to avoid the probate process upon the property owner's death. So a question I get asked a lot is, can I add my kids to my deed? So when I pass away, they automatically own the property. Or can I just transfer my property to my kids so that way, if and when I pass away, they have the property and they don't have to go through probate? You can do those things, but they're a bad idea, and here's why. By adding your children to your deed, number one, you're giving them whatever percentage, depending on how many children you add, you're giving them that percentage of ownership in the property. So if there were ever any sort of disagreement with regard to how to handle the property, you lose a lot of that control. You could also run into issues with Medicaid. So if you are either on Medicaid or planning on applying for it, if you're adding people to your deed or deeding property away, that is gifting a very large asset, and that could affect your eligibility for Medicaid unintentionally. So that's another reason why I don't recommend it. Finally, the third reason is when you add people to your deed, those people's creditors could now attach to your property. So now you don't only have to worry about your own creditors, but now you have more people in the pot, so to speak, that their creditors could attach. So a way to accomplish the same goals, but kind of get around these sorts of issues, is to have a ladybird deed. And the way they work is the original property owner can go ahead and add a remainder to their children, a relative, a friend, whoever they want to give it to. And the deed is signed right away, but the transfer of title does not actually happen until the original property owner passes away. So we are not adding people to the deed that could decrease that original property owner's ability to control the property, to sell the property. They still have all the freedoms to do that. We are not increasing the amount of creditors that could attach to the property, and we are also not affecting or endangering any sort of Medicaid eligibility, because no transfer is happening until that original property owner passes away and their death certificate is recorded in the county where the property is located. So this does work to avoid the probate process, because that transfer happens automatically upon the property owner's death, but we don't run into some of those negative side effects that maybe people aren't thinking about when they're wanting to add children or other relatives to their deed. So ladybird deeds can be extremely useful. I recommend them a lot. If you have more questions about them, I would love to sit down with you and talk about them, or you could go ahead and post those questions in the comments. I'd be happy to address them, but that's kind of a brief overview of how they work, and how they can work to avoid the probate process and also not run into some of those issues that you can have by using a traditional deed. Charmaine, thank you so much for checking in. She commented that an FAQ sheet would be great. That is actually something that we are working on. That's one of our kind of side projects that we would like to get posted to our website. So as I can kind of take all of the information and put it all into one consolidated place for you all, as sort of a library of different topics, so to speak. That is something that we are working on, and an FAQ sheet is going to be part of that. So thank you for the suggestion. We will definitely work on getting that up for you. Again, if you are just joining us, please make sure to say hello in the comments, so that we know you are here. If you have any questions for me, I am here to answer those live, so please make sure to put those in the comments as well. You can also feel free to either in the event or direct message us questions throughout the week, and I will compile all of those questions and address them at our next Legal Lounge episode. So as questions come up during the week, just jot them down, send them over to us, and I will get those addressed as well. Not seeing any other questions, I will go ahead and address one more topic that I get a lot in my office, especially in this market right now. We are seeing a lot of escrow disputes with the highly competitive market that we're in. We see sellers wanting to accept higher offers. We see buyers making offers sight unseen and then maybe having a little bit of remorse down the road. So we're seeing a lot of escrow disputes right now. And so one topic that I wanted to address, because I get the question a lot in my law firm, is this term liquidated damages and what that means. So in the FAR bar contracts, both the FAR bar as is contract and the standard FAR bar contract, the escrow deposit is defined as liquidated damages when it comes to a seller's remedy if a buyer were to default on the property. So, or on the contract, I apologize. So if the buyer breaches the contract, the seller's remedy is to keep the escrow deposit as liquidated damages. What liquidated damages means is it is a predetermined amount of damages agreed upon by both parties. And it's set. There's no changing it. So normally when we pursue damages, we're pursuing actual damages. You breached the contract, I was damaged in the amount of $20,000, so I now have a claim for $20,000. Liquidated damages is not based on a party's actual damages. Again, it is a predetermined or pre-agreed upon amount that serves as damages no matter what the actual damages number is. So in the FAR bar contracts, that is the escrow deposit, which is why it is very important, especially if you're representing sellers, to make sure that that escrow deposit is substantial enough to compensate the seller in the event that the contract falls through and that is not the seller's fault. It falls through as a result of the buyer's breach. So when a buyer breaches the contract, the seller's remedy is to keep the escrow deposit as liquidated damages. So if our escrow deposit, by way of example, is $5,000, a buyer breaches, $5,000 is all the seller gets. Whether the seller's actual damages were $1 or $1 million, it doesn't matter. That $5,000 escrow deposit is the pre-agreed upon amount that the seller has agreed will be their compensation if the buyer breaches the contract. So when negotiating escrow deposits, that is a way that I would encourage you to think about it is, will my client be compensated in the amount that they deserve if the buyer were to breach the contract or not close on the purchase of this property? What is the value of holding the property off the market for a certain period of time, whatever the length of that contract is? Those are things that you and your client should be thinking about in setting that escrow deposit amount, because again, whether their damages are $0 or $1 million, all they get is whatever that escrow deposit amount is. So hopefully that made sense. If you have questions about that or would like to discuss it further, I would love to chat with you. Send us a message, send me an email. My email address and contact information is down in the banner below. But those are three of some very, very common questions that I get in my law firm from clients, from realtors, from investors, from different folks in the real estate profession. So I wanted to go ahead and address those with you. Again, this video will be uploaded to our YouTube channel, so if you would like to refer back to it, or if you missed this or any other episode, you can go ahead and rewatch those on our YouTube channel. Thank you all who have attended today and who attend week in and week out. We appreciate it. These episodes are for you. These are to get your questions answered, help educate you, help you try to avoid having to call my office and hire me to either sue somebody or defend against a lawsuit. We don't want to be in that position, and education can go a really long way in preventing those types of disputes and those types of situations. So if you have any last minute questions, go ahead and put them in the comments. Not seeing any, I will go ahead and just thank you all again for attending. I actually look forward a lot to these episodes every single Monday. They've been fun for me. They keep me on my toes. I love your questions, and I love getting to chat and interact with you all in different ways throughout the week. So we will be here next week, same place, same time, Monday at 12 o'clock on Facebook Live. Look out for our event. I'll go ahead and get that posted on Facebook so that you can go ahead and RSVP for that. And then you can go ahead and put your comments or your questions as they come up throughout the week right into that event, and I will make sure to address those next week. Thank you all so much for attending. I will see you next Monday.